Hi guys, how are you doing today? Hope you are all having a sunny day. And if not, always remember that after every storm, the sun always shines. So, are you ready for new crazy stories I've prepared for you? I have 5 for you today. Let's go to the first one, about OP, who wants to sue her mother-in-law because she ruined her wedding dress. Listen till the end, guys, to hear my insights. Enjoy the stories, guys, and don't forget to like and subscribe. And of course, don't forget to leave a comment. I'm located in Virginia. I purchased a wedding gown that cost me over $11,000, then paid substantially more in alterations. Over the weekend, my future mother-in-law decided to attempt to put on my dress and failed horribly. Long story short, it's beyond repair and completely ruined. I also have reason to believe that she caused deliberate damage to the dress because of certain areas that were torn. My fiancé doesn't believe that we're able to take her to court to recoup the money because it's just a dress, and he thinks the cost of the dress doesn't meet some financial threshold to sue her. I want to know if that's true, and if it would be feasible to file a police report on her because of the more deliberate damage. I know it's just a dress, but this goes beyond the dress. OP's fiancé is incorrect. OP can absolutely sue her future mother-in-law for the value of the dress, plus alterations, if she can document that the dress is beyond repair. However, this is not taking into consideration the relationships aspect of the issue. So OP'll really want to take this there and get some more practical advice, and how it's going to affect her future relationship with her future husband. I can somewhat understand why OP's husband might not be excited about the prospects of his wife suing his mother. Despite the relationship aspects, ultimately, if someone damages your property through intentional or neglect actions, even if they didn't expect to damage your property, you're entitled to being made whole. Personally, if OP's fiancé doesn't back OP on this, I'd be thinking hard about whether she can trust him on other issues too. My wife had an affair last year. I asked for a divorce, a process which has begun. We have no children, but own a large detached house together. We are both on the mortgage and both on the deed. About 40% of the mortgage has been paid off. My wife has invited 2 of her sisters and their children to live in our home. Every bed is now occupied and there is nowhere for me to sleep. The families have all set their correspondence to our home. During the court proceedings, my wife told the court that the house could not be sold as it would make 5 children homeless. The judge agreed with her, but as there is nowhere for me to sleep in my own home, I have been made homeless. I am currently living with my parents. My wife has also stopped paying her half of the mortgage. 75% of my paycheck is now going directly to the mortgage payments, 15% on car payments, which leaves me only a few hundred to live on each month. I forgot to mention, whenever I go into my home, she and her 2 sisters follow me around room to room, glaring at me very closely. My job is partly work from home. When I try to work, they also make sneering remarks, crowd around my desk, and be too loud until I leave. I also have had important documents, like my birth certificate, damaged by crayons. They say it must have been the kids. Okay guys, this sounds like revenge to me. In my opinion, OP needs to report this to his lawyer and the courts. She stopped paying her share. Actions have consequences. OP should let her buy him out, and if she refuses, then start the house selling process. Judge needs to know what OP's wife is doing. I strongly suggest OP also keeps a diary of every incident, no matter how little and insignificant it may seem. Writes it straight away as soon as possible, so his emotions will be written down as they are at that time, rather than trying to remember looking back afterwards. It could help his argument about what she is doing and how OP is being treated, which will allow a judge to make more of a fair decision. She is obviously playing the emotional blackmail cards with OP, being a nasty person, making those kids, that are absolutely not OP's responsibility, homeless. My ex lives in Sweden. He is a citizen there. I live in England and am born here as a citizen. Me and my baby were to move to him once she was born, but unfortunately, he left halfway through the pregnancy for another woman. I had to have and still have therapy due to the manipulation, lies, gaslighting, etc. I had to go through pregnancy alone and birth alone. Our daughter is now 4 months old, and I've refused contact with him so far. mainly as my emotional mental health suffers when I do. Until I feel strong enough, I need to keep him out. I didn't put him on the birth certificate, as I didn't feel safe with him being manipulative and in another country. Also, he wasn't here to sign it anyway. He is now blowing up my phone trying to demand to let him take the baby to his country for visits and to let him spend time with her whenever he wants. I have advised I am not ready for contact, as I need to heal, and I don't know when I will be ready. He has threatened to get a lawyer and a blood test if he has to. This has panicked me. I have told him if he moved here to be a father to her, then I will set up visits, but he can't really be a father a whole country away and drop in and out whenever he feels like it. I'm just concerned he can force me into it when I'm not ready yet. I still struggle sleeping and extreme betrayal trauma. He is sending money for her each month though, so I give him that at least. Where do I stand legally? Should I consult with a solicitor in case? Unfortunately, the affair partner, girlfriend, I don't trust either. Am I missing anything I need to do? He is not on the birth certificate, so he would have to bring an action in the courts here. This is where the child is habitually resident, so this is where applications will be heard. He could apply for a declaration of parentage, i.e. DNA test, and then be registered as the father, yes, but that is just one stage. Once that's done, and he has PR, then he has to convince a court to allow contact. Of course, these things are not binary. Contact can be in varied forms, from video only all the way to unsupervised visits, with time-limited supervision in neutral centers in between, etc., etc. But the base position will be that the child does not have a right to form a relationship with both its parents. That said, there are years for this to be done. Certainly OP and her solicitor will put forward the argument that due to his effects on OP, and the effects OP will have on the child because of it, it is not in the child's best interest for contact to be ordered, or whatever extent is asked for, at the moment. Certainly, to put the burden of international visits on OP, I think may be too far. Video contact may be the extent of it. I think frankly that it will be unlikely, absent some kind of exceptionally discreditable behavior by the other parent, that OP will be able to bar all contact until age 18. Definitely OP needs to see a solicitor if proceedings are coming her way, so they can put all this forward to the judge in easy-to-process, legally, terms. And OP needs to continue to seek mental health assistance for what this person has done to her. Best of luck, OP. I'm going to try to keep this as short as possible. Father-in-law started having an affair last year. He allegedly stopped after mother-in-law found out about it, and they were both dedicated to making it work. Mother-in-law has been getting cancer treatment the whole time. She discovered that he was still engaged in the affair. Thanksgiving, mother-in-law told him he needs to choose. When she wasn't home, he took all of her dogs, 4, packed up one of the work vehicles, and drove down to Florida. Mother-in-law has been alone since. He refuses to deal with the business. Mother-in-law, who again has stage 4 cancer, has been dealing with everything, and father-in-law is threatening to never come back if she tells people why he's gone. He ignores any clients and makes her call them, makes her do quotes, and now she's going through an unemployment audit by herself. He mailed her divorce papers yesterday. She wants to know a few things. 1. Iowa is a no-fault state. So does his illicit affair, abandonment of his business, refusing to pay bills, taking the work vehicle, and worsening her medical condition play any part in the divorce? 2. If the divorce is going to be a fair 50-50 split, is she allowed to gift her son and I a large amount of money? She wants to protect herself and us. He is her only child, and we want to start having children soon. She doesn't want to lose everything, but feels like she's going to. She asked me to look up if there is a way to hide some money to ensure she would be able to continue living. There's no way she can get a job after the business is dissolved, and help with her future grandkids if she loses her fight to cancer. I told her it's not a good idea to try and hide things because it can make things worse for her in court. So she asked about a monetary gift. Divorce attorney before anything else. If OP's mother-in-law hides money, or gifts money, or does anything else suspicious, the divorce court can penalize her for that. It's not her money. Even if he's an a-hole, it's still their jointly owned money. Trying to prevent him from getting his half is both legally and ethically wrong. She needs to hire an attorney to protect her half. That is the goal. No, the affair likely doesn't matter to the court by itself. If he spent a lot of money on that affair before the divorce is filed, the court can perhaps take that money out of his half of the division, though. So if he's buying her cars or paying for her house or any of those things, that's relevant and needs to be documented. Divorce attorney will be able to do wonders for making her feel less anxious. I know it sucks now, and dealing with this while running a business and fighting cancer is daunting. But a lawyer will be able to lay out a roadmap for the next few months that will show her that she can make it through this. After having an affair, my wife Anna decided she needed to spend more extended time with her family in Ohio by herself, and we agreed that I would take care of our dog Oliver while she was away. A few weeks ago, Anna informed me that she was coming back that weekend to pick up some things and take Oliver to her parents' house with her. I was traveling and had Oliver with me, so I told her that we wouldn't be there, but more importantly, that we needed to have an actual conversation about this. She never followed up. The following weekend, I was going on a trip with some friends and asked my parents to watch Oliver, as they have done many times before. I mentioned to Anna on Friday where I was going and that my parents would be taking care of Oliver over the weekend. The next day, without telling me, Anna made a 12-hour round trip to my parents' house to try to take Oliver while I was gone. Anna waited several hours into the drive before contacting my parents and led them to believe that she was visiting friends in the area and had coordinated this with me. Luckily, my parents mentioned something to me, and when I told them that I knew nothing about this, they told Anna that they were not comfortable with this happening behind my back. Anna showed up anyway and ended up sitting in my parents' driveway for hours, demanding that they relinquish her property, despite being asked to leave multiple times. She eventually left without the dog. I've since been contacted by an attorney who is claiming that because Anna was the one who signed the adoption papers and we adopted Oliver while we were engaged, our dog is considered her separate personal property, which I am obligated to relinquish to her, and that, by the way, Anna wants a divorce. I love this dog like a child. I was the one who named him. I was the one who contacted the foster program about adopting him. I work from home, even pre-virus, so I am definitely the one who has spent the most time with him. Anna's parents have 2 other dogs that are very territorial and bully Oliver whenever we have visited with him. And even if Anna were to get her own place, Oliver gets very anxious when he's by himself, and I worry about him being alone for so much time while she's at work. Is her lawyer bluffing, or do I really have no choice but to just hand over our dog and risk never seeing him again? Edit. I'm told it might be relevant that I am listed as a co-owner with Oliver's vet. Anna took all of Oliver's papers and medical records from our apartment while I was gone, but I was able to have them email me new ones because I am already on file with them. OP should ignore her lawyer. And guys, never take legal advice from the opposition. Dogs are property. Ownership of the dog will be settled in divorce court, like everything else that the 2 of them own. In the meantime, OP needs to make sure there is never a time when she can just walk in and take the dog. She has equal rights to it. OP cannot keep his wife out of their joint residence, so he needs to make sure he doesn't leave the dog there alone. Also, she is lawyered up, so OP needs to hire a divorce lawyer yesterday and have them inform the other lawyer that they're representing him and that all future communications need to come through them. OP needs to start treating her as the opposition. Stop talking to her. Keep physical possession of everything, whether he wants it or not, and especially if she wants it. I've been there. It's not fun, but it does get better.